have a question for you.
Okay.
You said there were 9,000 eligible lawyers who are able to vote, but almost half of them did not show up to vote. Do you think this could have been influenced by the changing demographic of lawyers in LSK? We have more young lawyers now making up LSK than the senior lawyers. And previously, when I hosted a few young lawyers here, they said that the issue of Nelson Harvey was going to create a problem, and the young lawyers would feel like their voices are not being heard, and they would boycott and stuff. What about this issue of your experience, the practice age experience? Silvio, isn't that what you
that's it.
Do you think it's fair as a young lawyer? Like, do you think Nelson Harvey... Okay, law is usually known to respect seniority, the older lawyers and what have you. But do you think because of the demographic that's changing, you guys should actually change that law? What do you think?
I just wanted to add my voice first to the first question about lost glory. There is a book that I read so many years back called Henry VI by William Shakespeare. And in that book, there's a character who said, the first thing we must do, let us kill all lawyers. People who do not understand literature have always thought that they wanted to kill lawyers because they were bad. And that is not the situation. They wanted to kill lawyers so that they could loot the government coffers. So back then, lawyers were a revered group of people in the society because they were the gatekeepers of the public coffers. And when the people who were put in the throne wanted to fleece the government coffers, lawyers stood against such kind of vices. And therefore, they wanted to kill all lawyers. Now, presently, you said that even the parliament sometimes does not take seriously the opinion of the Law Society of Kenya because we are no longer what we are supposed to be. We always have rallying calls, election after elections. And last time it was Okoa, LSK. Kama tuliokoka, I still doubt. Or we backslid, and we backslid badly. And lawyers must stand up. It is only lawyers who can always stand up against any vices from any quarters in the society, be they from government or opposition. It's lawyers who are moral custodians of the society. And if lawyers are becoming cold by the day, then we have a reason to worry. Now, about the apathy about people not attending elections, it might have been contributed by, you see, the Nelson Harvey's call on young advocates. And generally, they are young advocates. Most of them align themselves with Harvey's proportions and way of thinking, so that there is an age gap that you cannot do certain things before you reach a particular age. In my village, we respect age, but we revere achievements. For you to be an advocate of the High Court of Kenya, it means you've gone through some things and you are eligible therefore to do whatever any other member can do. But I have to say that with a pinch of salt because there's also beauty in experience, and having that term limit is not that bad, but it should not be a 15, it's just too much years. Some of us may die before them. Some of us who have hopes of vying. So it should be reduced a bit so that even junior advocate can vie for those positions. Because you say you're voting, but you can't vie. You see, Avi said that can't vote, can't vie, can't vote. So the work of young advocates are therefore voting machines, and that's not very good. And even in that law, the LSK of 2014, which we've been citing here, it says that if you have vied in a council, as a council, whichever other positions you vied for, then in the next one you are eligible to vie for presidency. So maybe I'm in 5 years in practice, then I vie for council and succeeds. Then after that I can vie for presidency. So you see, it doesn't make sense. So that the other person will have to go 15 years, while some people can use shortcuts to go less than that. But turning the low turnouts, some people are just not caring about what the society is saying anymore. It might not even be that the young lawyers did not turn up. We don't know which people did not turn up, but it was around 5,000. I don't know, that is it was low turnout, but I can't peg it because it was Harvey. Because if you see, Nelson Harvey also told people, now go and vote. There's a time he told us, he told young lawyers, do not vote. Then he started endorsing some other candidates, telling people not to boycott. So it might not be really about the age thing or something. I don't know what happened, why young lawyers, or most of the lawyers did not come to vote. Yeah, but going forward, I think lawyers should need to reclaim that glory you're talking about. Yeah, we need to be standing at the gatekeepers against human rights abuses, every other kind of abuses, fleecing public offers, and that lost glory will come. Let us give the council which has just been put in place to do their work. We will judge them at the end of their term.
All right. Oh, yeah, there's something that you said that I was going to ask about, the impact of social media during this particular elections. Harvey's influence has been pinned mostly on his influence on social media.
Exactly.
How do you think social media as a tool can be useful to LSK going forward?
Yes, two things, and I would want to touch on something that Gora said before I talk about the social media bit about young lawyers. You see, we've been told that young lawyers are not allowed to vie and vote, but there is no definition of where young lawyer is out there. So we don't know whether this is a lawyer who's practiced for 5 years or less. You know, we don't know whether it's a year, 10 years or less. So we really need to be clear about who a young lawyer is. But that is not important for me, because then it is creating an unnecessary wedge between lawyers, so that we'll be in a club called a young lawyers club, then another one called a middle-aged lawyers club, another one is a senior lawyers club, the aged lawyers club. We don't need this. The bottom line is, if the society is to move forward, then we all have to go in one direction. And maybe I'll get an opportunity to address the Harvey case at some point. But we cannot boycott voting because we were not represented at the ballot. Because when you look at the Harvey case, what the courts are saying, Justice Mativo is very clear, that it is not the role of the court to now do away with the age limit thing. He says that that is the function of the members at the AGM, that when we convene, then we make proposals, and then if it's done away with, that's okay. But to get to the AGM, we must have an elected office, right? To get an elected office, we must go to elections. To go to elections, we must have participants in that elections. So it's important that we participate in the elections, we get members to office, then now we question at the AGM some of these things, you know, and how they sit in with the wider constitutional principles as to elections. For example, you will notice that in the previous constitution, we had the age limit for the president set at 35. With the Constitution of Kenya 2010, that was done away with. So to address these things, we must still participate. Now, to come to your question about social media, it is undeniable that we are in the social media era. And whoever uses social media to great effect is likely to carry the day in any event in today's world. Harvey used that to great effect, if you ask me. And the importance of that is that, you see, we live in a virtual world where I may not be meeting Hilda every day, but we may be WhatsApping every day with Hilda, and virtually we may know how each other is doing even without physically meeting. The challenge has been that as you go ahead in your age as a human being, you are not accustomed more to technology, so to speak. So you find that young advocates are more accustomed to technology. Today, I read my emails on my phone.
I would beg to differ that young advocates are the only ones who are active on social media. Last week we found an interesting incident, a small Twitter beef between the CJ, Justice Maraga, and Ahmed Nasir, where Ahmed posted on Twitter that it is the judge's voice that counts, and not the lawyer's voice. The lawyer's voice is neither here nor there. And then we had the CJ responding during a hearing last week on Friday, saying that are you litigating this from here or from?
Well, there was that twiff. We call it twiff. Twitter beef is called twiff.
But I'd like to pick on what Ahmed said about the lawyer not having a voice and the judge having the main voice. Julius, what do you think about that?
I think that's his opinion, because usually lawyers speak. I actually say that lawyers carry the burden of the public. Lawyers carry the problem of the public, and they present the problem they're carrying for the public before the judge. The role of the judge is to listen to what the public is saying through the lawyer and to give an opinion. So that if a lawyer should think that the judge did not listen to what he said, and make a pronouncement on it, there are channels to challenge that. There's a hierarchy of the judiciary from the lowest to the highest. We start with magistrates. If you think you made a good presentation before the magistrate, but at the end of it, the verdict does not make a mention of what you said, you've been ignored, you move to the High Court. From there, you move to the Court of Appeal. And then you move to the court we call the Court of Last Error, where if there is any error made, there's nowhere else you go to. But for you to say that it's the judge's voice that counts, it means you're accepting that you may not be in agreement with what the judge may have pronounced, but you're abdicating your duty, which is your duty you are carrying on behalf of your clients, to challenge what the judge has done in the before the next panel of judges. So that I think that's not a fair comment, my opinion.
All right, Ocheng, do you have any literature for us?
Yeah, literature is what lasts. It is the stories that remain. Even when we live here, it is stories that will remain. And about lawyers and judges, I think first of all, if I want to look at him a bit flimsily, it is splitting hairs. I thought judges are lawyers also. We just cut from the same cloth. And it is not right to say that lawyers' voices do not count. If there are anything, it is the lawyers who first go to court. Judges do not go around looking for cases and bringing them before themselves. It is the lawyers who go to those courts, then argue their cases. If the cases, facts and law supports their case, then the judgment will be in their favor. The judgment can also be against you or your client. Then you move, as my friend has said, to higher courts. So I think the opinions of lawyers do count. And you see, if we slip into this thing of it is only the judges' voices that count, then it will drift us back into the some eras of when judges could just be waking up in the middle of the night and making some declarations to arrest people arbitrarily, and it was done by the judges. So if we need to start saying that it is only the judges that count, then it will be, the justice will be for the highest bidders, and we do not want to go that way. So I think that okay, we respect our seniors' thought process, even though sometimes I will disagree with him most of times.
All right, so now let's move back to LSK. Gishu, had in his manifesto, he talked about how he would like to address hindrances to the successful practice of law. What does that mean? What hindrances are you guys going through as lawyers?
We must first of all address our minds to the fact that whatever it is the LSK president is coming to do is already laid down in statute. Section 4 of the LSK Act is clear on what should be done. Now, what we do in campaigns, in setting out manifesto, is just explaining how it's going to be done, how we are going to achieve our manifestos. To come back to Allen Gishui, Allen majorly practices law, meaning Allen is a litigation lawyer, so he goes to court. So when you look at his mantra, he says practice matters. It is only reasonable that because he's a practitioner, he would be leaning towards practice. And to your question as to what are the hindrances to the practice of law, it starts way back from the training of a lawyer. So that when a lawyer gets out of campus, he's required to go to the Kenya School of Law. At the Kenya School of Law, you are told that you now have to pay the sum of Kenya shillings, 190,000 shillings, you know. And this figure may be too high in certain instances for, people who don't come from well-to-do families, and it may be a hindrance joining KSL when you've cleared your campus, so to speak. At the Kenya School of Law, your problems don't end even when you get admission. We have an examination method at the Kenya School of Law carried out by the Council of Legal Education, CLE, and the Kenya School of Law, where you are examined on 9 subjects. To be successful, you must pass all the 9. The pass mark is pegged at 50% of the marks.
Is it achievable? Is it easily achievable?
Well, we don't want to deride lawyers and say they are not intelligent people. So we've achieved it. That's why we are here. But we've had questions about the examination method at the Kenya School of Law, because consistently you find that the pass rate is something between 16 to 20% of the students, and well, by any standards, mathematical or otherwise, that's a really low figure.
Yeah.
So questions have been asked, what is the idea behind the massive failure rate?
Yes.
Is it the examination method? Is it that the body charged with this mandate wants to make money? Because you know, when you fail a paper, you either receipt or remark the paper. When you receipt the paper, you pay 10,000 shillings per paper. When you remark the paper, you pay 15,000 shillings per paper. It doesn't matter that at remark, you may be successful. You know, if you succeed at remark, it means the examiner was initially wrong, right? But you still pay the 15,000 shillings. So we want to look at KSL, because KSL is a very important body.
Yes.
As regards the training of lawyers coming into practice. So that's one of the things I expect Allen to address when he talks about, you know, practice matters and addressing hindrances to practice.
Yeah.
Then the second thing is that after you are done with the Kenya School of Law, you go to pupillage, where you receive training from an advocate of more than 5 years standing for 6 months.
Okay.
You must note that a majority of lawyers engage in what we call private practice, meaning that my law firm is my private property. It's not a government institution. So the prerogative on whether to take a pupil or not is purely the advocates. So
no, that looks like, yeah, that's a big problem.
It is a big problem.
They had a really big
Yes,
issue
it is a big issue that must be understood in that context, because then we still say that an advocate can only take a maximum of 2 pupils. So I may be willing and able to take more, but by law I can only take 2. Someone else may be able but not willing to take any, and you can't force them to take no one. You know?
we need to wind up. I'd like to hear what Julius thinks and what Ochieng thinks before we finish.
Okay, to that question, I want to look at it from a different angle. Let me look at it from the perspective of somebody who has undergone the full process that my colleague is explaining, and has been now admitted to the bar to practice law. And that's what we call in where we come from, bread and butter issue. Because when we wake up each morning to go to work, we go to practice law, and that is where our source of livelihood is derived from. Now, what are the challenges that we expect Gishui Council to handle? There's so many. It depends on which area of practice somebody is involved. But I want to look at it at least from the perspective of litigation practice. There are quite a number of challenges. One of them is the slow pace at which cases move, and that prejudices not only the client on whose behalf you are practicing, but also you, because you do not want to pick a case that will hold you for 5 years before it's concluded, when you want to get over with it and pick the next one.
Actually, Gishuli actually spoke about that. He said about expediting the hearing process.
Yes. And so there are many reasons why cases would delay. One of them would be the unavailability of judges or magistrates. Reason being that the court station may be understaffed, or the magistrates or judges may be overwhelmed, and so they can only do so much. So what I would expect the council led by Allen to do is see how we can get more magistrates hired, see how we can get more judges, especially judges in the areas of land, which is highly understaffed, and in the areas of employment disputes, which is equally very highly understaffed. Once we get that sorted out, then our bread and butter issues will also get sorted.
Okay, Ochieng, any parting shots to conclude this? We'll carry on this discussion next week, but we have to finish up.
Okay. About the challenges that we face, I will not go so much into that. I think my colleagues have adequately addressed that, except that for maybe criminal lawyers, there are times you can go to bail out your clients when they are arrested, and you're also arrested with them. So you're told, oh, you're the lawyer, you've come for your client. And yes, what do you want to do with him? And he has rights. Okay, get inside there and teach him his rights. So you see, as a lawyer, you are also inside the cells. So I think for criminal lawyers, that is what needs to be addressed. Now, parting shot. I'm still urging the people who have been elected. Actually, the credit goes to you, as it was said in the year 1910 by Roosevelt, when he was addressing a gathering in Osborne in France. He said that the critic does not count, not the man who points where the strong man stumbles, not the man who points where the doer of the deeds could have done them better.
All right.
The credit goes to the man in the arena whose face is marred with blood, dust, tears, and toil. So I want to congratulate those who have been elected into the office, and even those who are not elected. Kindly, if you had good manifestos, just let your colleagues carry them out, and let us have the glory that is lost as lawyers. We can still stand and guide this country. I think the judiciary and even the lawyers included are the last arbiter. Thank you.
All right, thank you so much for joining us. I think we need to have more when it comes to LSK. You have been watching Youth and Politics. I am Hilda Wadidi. Do stand by for Man Crush Mondays with Valentine. Do not touch that dial.